1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်963 In the matter of RAMNIRAJAN LHILA DEBTOR versus DOTAN APPLICANT ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Insolvency case before ဦးကျော်ဆန်းဦး Judge in the matter of RAMNIRAJAN LHILA DEBTOR versus DOTAN APPLICANT Rangoon Insolvency Act Section 9C Commissions of an Act of Insolvency by the debtor under Rangoon Insolvency Act Section 11B Order of Adjudication under burden to show that the court has jurisdiction to entertain the petition. Definition of ordinarily recited proof that the debtor normally or usually ate, drank, and slept at the place. Requirement by lot of clear and unequivocal evidence to adjudicate a person insolvent. Proof that the property in question is a dwelling house. Proof that it belonged to the respondent during the requisite period of time. Hell, the burden lies on the petitioner to show that the court to which the petition for adjudication as insolvent is presented has jurisdiction to entertain it. Matt Ho, Patient versus A.I. Walton, 1913, 18, CWN 1050, 1052, refer to Hell further, the petitioner must prove that the respondent has normally or usually ate, drank, and slept at the place in order to call it a residence. R versus Inhabitants of North Kari, 1825, 107, ER 1313, in Re Oldham, 1817, 10, M&H, 158, Kumat, Nat Rai, Chudhari versus Jodindra, Nat Chudhari, ILR 38, Kalakata 394, refer to Hell further, to adjudicate a person insolvent, there must be clear and unequivocal evidence required by law. There must be clear proof that the property in question is a dwelling house and that it belonged to the respondent during the requisite period of time. H.M. Fisher for the applicant, 1 Hook for the debtor, Uကျော်ဆန်းဦး Judge. This is a petition by the creditor, DOTAN, to adjudicate her debtor, RAMNIRAJAN LHILA, and insolvent. He alleged that the debtor has committed an act of insolvency under Section 9E of the Rangoon Insolvency Act, and this court has jurisdiction to make an order of adjudication under Section 11B of the Act, as the debtor has within a year before the date of the presentation of the petition, 11 June 1965, 1. Ordinarily resided, 2. Had a dwelling house being numbers 52, 54, in 29 Street, Rangoon, and 3. Carried on business within the limits of the ordinary original civil jurisdiction of this code. The debtor respondent, through his agent, denies the allegations. The burden lies on the petitioner to show that the court to which the petition is presented has jurisdiction to entertain it. See Burma Law of Insolvency, 2nd edition, paragraph 191A at page 188. Evidence was given by the agents of the parties. The petitioner, though present in court, did not go to the witness chair to give evidence. If any precedent is required as to the burden of proof, I need only refer to Madho Patient vs. A.L. Wilton 1. According to RAMNIRAJAN, the agent of the respondent, his principal, left Burma for India on 2nd March 1964. There is in fact no dispute that the respondent had left the jurisdiction of this court well over a year before the date of the presentation of the petition. In Exhibit number 1, the petitioner did not deny that the respondent had left Burma on 2nd March 1964. Her agent U.A. Nyo also admitted in his evidence that he saw the respondent in the summer of 1964 for the last time. The petitioner case is that the respondent ordinarily resided in his dwelling house known as 52, 54, 29 Street, Rangoon, but there is no proof at all. It is clear that the respondent did not ordinarily reside at the place within a year before the date of the presentation of the petition, 11 June 1965. He was in India during the period and stayed there. The petitioner agent U.A. Nyo deposed that he visited the place for the last time in or about 1960, 1961, and he spoke only to the respondent, though it was occupied by his mother, brother, and family as well as by the tenants. When he was asked, "Do you know that in 1964, LHILA actually resided there?" he replied, "After March 1963, I did not know that LHILA actually resided there." To make the point more clear, his depositions are reproduced here. Question: and you do not know also whether he had given at the place and had gone to India or not? Answer: I do not know. Question: in 1960, 1961, you had been to LHILA house and after that you have never been to his house? Answer: no. According to Bailey, Judge, in R versus Inhabitants of North Kari 2, the word reside denotes the place where an individual eats, drinks, and sleeps, or where his family or servants eat, drink, and sleep. And Blackburn Judge, in Re Oldham 3, observe, a man resident is where he habitually sleeps. Residence is not identical with ownership. A person may reside at a place, but he may not own it, and vice versa. These views were adopted by the bench of the Calcutta High Court in Kumat Net Rai Chudhari vs. Jotendra Net Chudhari 4, where reference was made to Order 5, Rule 17 of the Code of Civil Procedure, in which the words ordinarily reside appear. The word ordinary is defined in the Oxford Dictionary as regular, normal, customary, usual. Hence, the petitioner must prove that the respondent has normally or usually ate, drank, and slept at the place, but she has failed to do so. The next point for determination is whether the place known as numbered 5254 in 29th Street was the dwelling house of the respondent within a year prior to 11 June 1965. I do not think the petitioner has satisfactorily discharged her onus of proof on this point. Her learned advocate find a certified copy of the assessment list of the Corporation of Rangoon in respect of the aforesaid property. It is not a document of title. It is for the year 1961, 1962, and the name of the owner is shown as RAMNIRAJAN LHILA Uenyo deposed. Question: don't you think that instead of making inquiries the whereabouts of LHILA, is it not better to visit his dwelling house and find out? Answer: I went and made inquiries, but I did not see him. Question: so after 1960-1961, whether LHILA was still in his dwelling house in numbered 52, 54, 29th Street, do you know? Answer: I knew that it was his dwelling house. Question: do you know that in 1964, LHILA actually resided there? Answer: after March 1963, I did not know that LHILA actually resided there. Question: and you do not know also whether he had given at the place and had gone to India or not? Answer: I do not know. Question: in 1960-1961, you had been to LHILA house, and after that you have never been to his house? Answer: no. Assuming that the place known as numbered 52, 54 in 29th Street was a dwelling house, Uenyon evidence does not show that it belonged to the respondent or that he resided there within the required time. I have referred to Civil Execution number 11 of 1963 of this code as requested by the parties. It is a case where the petitioner attached this property in execution of her decree against the respondent. I find the address of the respondent was given as numbered 50, 29th Street, Rangoon. This was confirmed by RAMNIRAJAN in this case. The order of attachment was issued on 22nd May 1963. In the sealed proclamation, however, it was shown that the building comprising of 7 rooms was in occupation of the tenants and its site. A freehold land was in the name of Mr. S. Potter, being the ancestor of the judgment debtor. Only the right title and interest of the judgment debtor were to be sold and the intended purchaser were one to satisfy themselves as to the judgment debtor title to the property. The record does not show that the property was the respondent's dwelling house at the time. It shows his father was Sandley, the learned advocate for the respondent, submitted that in the absence of ration card and household list issued by the authorities, the point under consideration could not be pressed by the petition in her favor. To adjudicate a person insolvent, there must be clear and unequivocal evidence required by law. There must be clear proof that the property in question is a dwelling house and that it belonged to the respondent during the requisite period of time. The last point for consideration is whether the respondent within a year before 11 June 1965 carried on business either in person or through an agent. There is no positive proof that he did so. Uenyo evidence runs as follows. Question: before March 1964, did you ever visit the business place of LHILA? Answer: no. Question: so you do not know what sort of business he carried on? Answer: I knew through his agent, Sitaram LHILA, that they have a ribbon manufacturing business. This, of course, is hearsay. Sitaram LHILA was not examined as a witness. Uenyo admitted that the government had nationalized factories in March 1963. He learned from Sitaram how this factory was run after nationalization. He has no personal knowledge. RAMNIRAJAN, on the other hand, deposed that to his knowledge, the respondent did not carry on any business in Burma after his departure on 2nd March 1964. In the above circumstances, it cannot be said that the petitioner has successfully discharged her onus of proof. It must therefore be held that this court has no jurisdiction under the Act to adjudicate the respondent an insolvent, and accordingly, the petition is rejected with cost, advocate fee, 5 gold mohurs.